Good morning. We are starting chapter 9 today, and it's also sort of a turning point in the course for us because we're in our last three subjects: torts, property, contracts. Torts will be on exam 2 and property and contracts on exam 3. But we have also gotten past a lot of what I consider to be the sort of the groundwork laying prefatory material into what I always characterize as the big three subjects of civil law. And remember, I told you we're dealing with civil law in this class, not criminal law. Although, as we're going to find out, torts is probably that area of civil law that comes closest to the criminal law, for those of you who are interested in it. And we'll talk about that a little bit today. But the reason I call these the big three areas of civil law is because they are the three on which an overwhelming majority of civil litigation is based. In business, in particular, the two big ones of the three, although property with intellectual property issues is coming along nicely now, but historically, the big two issues have been contracts, which is why we're doing 2 weeks on them at the end of the semester, and torts. And depending on the sector that you're in, as I discovered when I collected a big data set for a journal article about a year and a half or so ago, depending on the sector that you're in, tort law might actually wind up being more important to you if you're in retail or if you have an entrepreneurial startup that interacts with customers that, walk in the door or onto business premises. But torts might wind up actually being more important to the well-being of your business even than contracts at some point in time. And so we'll start by talking a little bit today about where torts come from. The words property and contracts advertise what those fields are pretty well, but a lot of people still have an issue with the word tort and don't quite understand it. As you can see, best-selling author John Grisham, as a former practicing attorney and multi-gazillionaire author, knows exactly what they are, and one of his bestsellers was a book entitled The King of Torts. But we need to sort of dig into the etymology of the word a little more and then figure out what exactly we mean by that word tort so that we can understand what we're going to be talking about this semester. If it helps, the second point on this slide covers an important aspect or an important goal of this week. We're going to distinguish between types of torts, and we're finding out that there are torts of intent and torts of negligence, but we'll talk about those momentarily. I've already mentioned that tort law is a central concern for all businesses, but particularly in businesses that deal with members of the public on a day-to-day basis in their business enterprise. So what I suspect will happen, it certainly seems to be the case from my experience in the 8:30 class this morning, is that today we talk about the introductory stuff and we talk about intentional torts. Wednesday we'll talk about torts of negligence. And then there's this curious sort of, I don't want to call it a third type, but it's a status in the law that is particularly important to business in product liability actions, where somebody manufactures a product and the product goes out and somehow it injures an end user and the end user says, there was something defective about the product that caused the harm, and I expect to be compensated for it because I had medical bills or I lost an eye or something like that. So we're going to talk about this word torts first and start looking at what we call the torts of intent today. Before I even get to the Black's Law Dictionary definition, which as you can see is extraordinarily long and complicated, let me tell you briefly about the etymology of the word. It came originally, I wrote them on the board because I decided to go old school and use the chalkboard technology. Can y'all see that okay? Sort of, kind of? I'll try to help and get out of your way. It came originally from the Latin word tortum, which is an infinitive verb meaning to twist. Tortum, to twist in Latin, which was picked up by the French, particularly the Norman French, with basically sort of in control of all of France. And if you know your history, you know that eventually the Normans invaded and conquered England, and so a lot of English legal history and experience, and a lot of the terminology we've come across, like voir dire, for example, is an English legal term owing itself to French origins. And so the French picked up this word tortum, meaning twist, and in French it became, at least in Old High Norman, it became the word torcher, meaning some form of wrong done to another, some kind of harmful act done to another. And so lo and behold, when the English came along, or I should say when the French came along and conquered the English, English law picked up that French sense of the word, a wrongdoing of some sort. But they shortened it, got rid of the suffix, and just started referring to it as a tort, a wrongful act done to another. When somebody is accused of a wrongful act done to another that qualifies as a tort, and that's going to take us into our definition in a moment, we have a word for them as well, although I'm going to mention it to you so you're familiar with it. But we'll just fall back on, for most examples, on the old plaintiff-defendant distinction, because that's the one that you're all, I think, most comfortable with for now. But one who has committed a tort is known as a tortfeasor. A tortfeasor, which is also, by the way, a great name for a cat. But the suffix, feasor, feasance, we've heard those terms before, and so I want to make sure you understand the etymology of the word feasance, because we use it a lot in the law, right? A tortfeasor is one who commits a wrongful act. That is a tort. You might have heard of other versions of the word as well. For example, if somebody said, practice beneficence in your life. Ben, meaning good, or benny, and ficence is a form of the word feasance, which means good acts. So go out and commit acts of beneficence. Do good acts in your life. If you make a mistake at something because you're sort of negligent, not paying attention, whatever, you don't intend to cause a harm, but you actually wind up doing so, that's going to be an issue in torts. You can be said to have committed an act of misfeasance, misfeasance, spelling bee time. Misfeasance just means I did something kind of goofy and it caused a bad outcome. And then, as we'll use the word later in today's class, there are acts of malfeasance. Mal from the Latin root malum, meaning intentionally bad, an evil act. Malfeasance is worse than misfeasance, because misfeasance is like, oop, I just accidentally blew up Australia. Malfeasance is, I just blew up Australia. So beneficence, malfeasance, misfeasance, and now hopefully you understand why a tortfeasor is one who commits a tort. Feasance, to commit an act. What kind of act? Our old friend Black's Law Dictionary has this very simple definition of a tort. It is a non-contractual civil wrong. And there are two important things to get out of that very simple definition. Thing number one, we know it's a civil wrong. It's not a criminal act. It's not something that the state will prosecute you for and throw you in jail. Although, as we're going to find out, there are a fair number of at least intentional torts that also have criminal analogs. That is, for example, assault and battery, which are classic torts. They've been statutorily turned into crimes in every jurisdiction of which I'm aware. So you could actually be locked up for committing a criminal act and also sued by your victim for committing a tort out of the same transaction. But we're talking about civil wrongs here and not criminal acts. The other part of that requires a little further explanation is the non-contractual thing. Why is it a non-contractual civil wrong? Well, because if it's a wrong that you commit to another party within the scope of a contract, a legally binding agreement between the parties, the party against whom you commit the wrong is going to say, they committed a wrong against me because they had an obligation under contract and they didn't live up to it. The most common example of that is a breach of contract. Hey, I paid you the $1 million, but you didn't turn over the $1 million worth of goods that I bought from you. You breached our contract. we'll deal with contracts in a couple of weeks. What about other wrongs then? Well, any other wrong that doesn't have a contract underlying it would qualify as a tort, because torts, as I say here on the screen under purpose of tort law, has always been, the way I think of it, kind of like the Swiss Army knife of compensable injury. There are lots and lots and lots of different ways without a contract that somebody can do a wrong to you and hurt you. They're skateboarding in the room with these steep steps as you're trying to leave at the end of class because they think it'd be fun to fly through the air and then land down here to amaze their classmates, but they don't realize you're walking up the steps and they smack into you, knock you down the steps, break your jaw, cause all sorts of other harm and damage to you. And there's no contract, but they've clearly committed a wrong against you. Oh, dude, I didn't mean to. Doesn't matter. Your actions resulted in harm to another. And so tort law is going to cover that situation and say your victim, the plaintiff in the case, can sue you for a tort. And then the next point is we just have to figure out which tort it is, which is part of what today's about. A traffic accident is typically, in fact, as far as I can think of, there's certainly no contractual element to it, but a traffic accident would be considered a tort, right? Whether the person, as is usually the case, doesn't mean to hit you but does, oh, I ran a red light and T-boned you. I'm so sorry, I didn't mean to. Well, that's a tort. I didn't mean it or I didn't mean to do it is not a defense because that person still committed what we would call an act of negligence that resulted in your suffering harm. You got to fix your car. If it's a bad T-bone, you got to go to the hospital and get your broken arm set. It's also possible that they're psychotic and waiting for you at the light, and they're going to give you payback for some insult at a party last week, and so they're waiting for you to approach the intersection, and they intentionally plow their car into you. That's a tort as well. That would be what we refer to as an intentional tort, but they've nevertheless committed a wrongdoing. So why do I think of torts as the Swiss Army knife of compensable injury? Because anything else outside of the realm of a contract in which party A does a wrong to party B that causes injury, tort law is there to run to the rescue and say, hey, injured victim, injured party. Look at my little blue thingy here. No injured party should be without a remedy at law. You were an innocent victim of the other person's, here are these words, malfeasance or at least misfeasance. It is only fair under the law, therefore, they pay the costs of making you whole again. You know, they can't magically wave their hand and fix your broken arm, but they can certainly pay you for your medical bills when you went to a doctor who set your arm to start healing it. If you had pain and suffering or time lost from work as a result of their act, you can be compensated for that as well. But no injured party should be without a remedy. So one of the main public policy purposes of torts is not only compensation for victims, but it's a legally sanctioned form of risk shifting. If you don't behave and cause harm to another from your misbehavior, it's not your victim that's going to be left holding the bag, it's you. A tort lawsuit will make sure of that by awarding your victim or victims damages in tort to compensate them for either your misfeasance or your malfeasance. Making sense so far? Hope? Upcounsel.com, by the way, I've got a little definition here where they say the main purpose of tort law is to provide a way to hold those who cause harm responsible, and that's what we were just talking about. So the next question is, what kind of non-contractual harm are we talking about here? What categories do those fall into? Two main types. There are torts of intent, aka intentional torts. It's easier to call them that. The tortfeasor, the party who commits the tort, means to cause what they caused. They mean to do it. Intentional torts the reason that intentional torts in particular are close to criminal acts is because in criminal law you learn that in order to hold somebody responsible for a crime, they have to have a certain state of mind. We call that the mens rea, more Latin, the evil or the guilty mind. Criminal acts rarely occur from negligence, although some exist, they're lower level offenses. Most criminal acts require the prosecutor to prove the defendant's guilty mind, their intent to cause the crime. With intentional torts, we also have that element in civil law that a plaintiff has to prove against a defendant. If I'm claiming that you committed an intentional tort against me, one of the first things I have to do is prove the intentional part. You meant to do it. Maybe you meant to do it to really screw me up, or maybe you meant to do it to scare me and I caused harm, but you intended to cause that act. Or to take that act, I should say, to cause that act. The other form of torts, and this is a much broader, bigger field, and certainly more applicable to the business environment, though intentional torts have their digs in these, are torts of negligence. Misfeasance, not malfeasance. I didn't mean it. Wow. I was negligent. I was careless. I was reckless. Something like that. Torts of negligence don't require a showing of state of mind. They require that somebody's conduct didn't meet a certain legal standard. That's the definition of negligence, when you don't live up to a certain standard. We'll talk about that standard when the time comes on Wednesday. But you don't have to mean it, and you don't have to have a guilty mind like you do with an intentional tort. You don't have to intend the harm that you perpetrated. You just have to compensate the victim or the victims for it, because you're the one who did it. So we're going to hold you responsible. So intentional torts and torts of negligence. And you can see the definition of these two at the bottom of the screen here. Let's see. This should be an easy question if you're awake. According to Black's Law Dictionary, a tort is a or an blank civil wrong. This is your chance to get some early tort question points on the board here. And thankfully, they're coming in fast. So we'll go 5, 4. I'm going to try to slow count it, but you got to get top hat up and running there. 3, 2, 1. Got it? And 0. Phew. Okay. Nick of time. According to Black's Law Dictionary, a tort is a or an non-contractual civil wrong. That's the definition at the top of the previous screen. So, good start on that. So let's talk a little bit more about the intentional torts. I've already told you this part at the top. They're most like crimes, although they are not crimes. But intentional torts are at least the most like crimes in the civil world, because they require an intent to commit the tort. And lo and behold, if you look at what we call some of these intentional torts, you probably are aware that there are criminal analogs to them in a lot of states' criminal codes. Be aware, however, that although the names of the intentional torts are long established in the common law, assault has been assault for, since the 12th century or thereabouts. States, because criminal law is often codified, it's often statutory these days, right? And so as states started to enumerate crimes and put them in their criminal codes in writing, sometimes they would play a little fast and loose with the names. And one example of that here at the top of the screen is that in the North Carolina General Statutes, if you commit a physical act of violence against another, you will be charged with the crime, probably, of criminal assault. The person committed criminal assault. If you engage in a rape or another sexually oriented physical attack against another, they call it sexual assault. Tort lawyers, on the other hand, if contact is actually made, would not call it an assault, but they would call it a battery. And because assault and battery often go together in the tort world, and especially in the criminal law, an assault and a battery can occur at the same time, depending on the definition of the crime. It's important for us to understand the difference between these two separate torts as intentional torts. And so I've grouped them up here with a little bit of an explanation. You'll notice some of them don't, because I can explain those, I think, pretty easily as we just kind of go down the list. But take a look at the definition of assault and battery separately. The tort of assault requires the intentional creation of the reasonable apprehension of immediate harm or offensive touching in another person. Nowhere in that definition does it say the harmful or offensive contact has to be made. It simply means that the party that is engaging in the assault intends to create the apprehension in the victim's mind that the harmful physical conduct is about to occur. In my other class, I borrowed my TAs as actors today, and I'm going to tell Jennifer and that they don't have to come down. Anna, I'm sorry. I need coffee. I really do. I only had one cup today. So I'm not going to ask them to come down all these steps. But I am going to borrow somebody. Do you willingly consider? No, you can stay there. That's fine. That's the good news about this, is you don't even have to get up. Because I can demonstrate an assault. Now you're sorry you volunteered. But for the fact that he now knows that he's being used for demonstration purposes, so it's not an assault. Because he understands that when I approach him with a seemingly harmful intent, I'm not actually going to hurt you. Now, battery's another story. You're in trouble. But here's an assault, right? We get into a fight at a bar or something, or after an accident, or just on the street we're walking past, right? And for some reason, I want him to think that he is in peril of getting the snot beaten out of him. And so I approach him with a clenched fist and I close distance rapidly. That's an assault in tort law. I have created the apprehension in him of a harmful physical contact. This guy's coming at me. Look out, he's got a pointer. Right? I don't have to touch him. The assault is complete at that point. Now notice, apprehension is not necessarily fear, right? If little 80-pound weakling is approaching big Bone Crusher Smith, the WWE heavyweight champion, with some device or instrument of harm, Bone Crusher is probably not going to be all that intimidated or fearful of our 80-pound weakling, but he goes, I'm going to get you, Bone Crusher. And he approaches Bone Crusher, who's kind of laughing. The assault is nevertheless complete because Bone Crusher anticipates that the armed weakling wants to do him harm, and that's enough to complete the assault. Right there. Here's the good news. We're going to pretend that I'm actually going to make harmful physical contact with this motion, but it's only play acting. Yes, ma'am. It sort of depends. If I'm back here and we're having this dispute because we're in different cars, and I kind of pull out my loaded laser pointer here, and I'm looking at him and doing this, is that an assault? It might be if a reasonable person would see that coming from somebody in an adjacent car and say, he's about to use it. Now, if I'm doing this, I say, you want some of this? Green laser pointer, right? If I'm pointing it at him, and it's a gun as opposed to a club or a knife or something, guns can obviously hurt people from a distance. So this would not only be a criminal assault, but it would also be a tortious assault, because if somebody's pointing a gun at me, if they're all the way across the courtyard, I'm still apprehending that they're about to shoot at me and I'm going to look for cover. What's a battery? Battery requires the actual harm or touching to take place. And that's why even in tort law, assaults and batteries often go together. We're arguing in the parking lot of the bar, and I say, man, I'm going to get you. You don't even have to stop note taking. I can do that like this if you want, right? But he's looking at me, and he apprehends the assault, and the assault is complete. And he says, gee, I wonder if he's going to boom, hit him in the face and knock him to the ground. That's the battery. That's the harmful or unwanted touching, and therefore the battery is complete as well. Brain question, not a top hat question. I gave you an example of an assault without a battery. Can you have a battery without an assault?
Yes.
How? Why? What?
They hit you before you know they're going to hit you.
He never saw it coming. I'm going to use my in student here for this, right? You can just like take notes. I'm not around, right? He said something a little earlier that really dissed me, and I'm really mad. I'd like to assault him, but I don't want him to see it coming. So I take my deadly laser pointer and come up behind him, and I'm smiling, and I go, wham! And I knock him to the floor, knock him cold. Goes to the, thank you. You're both very fine volunteers. I knock him to the ground. He loses some teeth. I fracture his skull. He needs EMS treatment. I haven't committed an assault against him because if he didn't see it coming, he couldn't have developed an apprehension of the harm. In fact, it was my intent that he didn't see it coming. He didn't apprehend it, because then he could defend himself. But if I just cold cock him from behind, that's an example of how battery is detached from assault. And both of those are chargeable torts in the world of tort law. So that's the difference between assault and battery. You'll see in a minute we're going to talk about the difference between two other similar torts. That takes a little more explanation, but I wanted to sort of go down the rest of the list on the left-hand side. These are a little more understandable by most people. Trespass to land, I've used that one before, right? The lady who walks her dog across my lawn, she did it the other day, by the way. I almost caught her, but I was in a hurry to get somewhere, so I didn't. But I stared at her, trying to create an apprehension of disgust. If somebody trespasses my land, which is requires real property of some sort, land or a house or a building, they have committed a tort. If they're there without my permission, they've engaged in trespass to land. And we have to call it trespass to land in torts because there's this thing up here, ta-da, that we're going to call trespass to chattels, which I'm going to get to in a minute. Intentional infliction of emotional or mental distress. The textbook goes into more detail about this, but in passing, I should note that this is not just what I would call butt hurt. This is not somebody who walks up to me and says, you're ugly and your mother dresses you funny, and laughs and walks off. Intentional infliction of emotional distress is typically significant or severe. It usually is conducted over an extended period of time, although it doesn't necessarily have to be. But it is what the law of torts would call a crippling or disabling condition that puts the defendant in mortal fear for their well-being, usually their life. Think of a stalker who calls and leaves messages at a target on the telephone or via the internet. Or you're leaving campus on a regular basis in your car and you notice the same little brown compact car following you all the way home over multiple days, and you take another route and they follow you down that other route. I mean, this is the stuff of Halloween movies, right? Things like that are what are required for infliction of emotional distress. So it's a pretty high bar. It's not just somebody insults you and you go, well, I'm going to sue you. You can't do that. Invasion of privacy. The common law recognizes that everybody has certain fundamental privacy rights. Now, not everybody has the same sphere of protection, and the most noteworthy exception to that is celebrities or public figures. The courts say if you're a celebrity, if you're a politician, if you voluntarily seek the limelight in your career or for whatever purposes, you still have a right of privacy, but the sphere of what we call your privacy rights is somewhat contracted because it's balanced by the public's desire to know more about you or its need to know. So yeah, the paparazzi can gather on the public sidewalk outside your mansion and take pictures through the crack in the gate. They can't send a drone to your bathroom at midnight to film in your window while you're taking a shower, because that's above and beyond the pale. These are sometimes gray areas in the law as well, so it's very conduct specific. But it's not arguable that the law recognizes that people have reasonable expectations of privacy, and when another party intentionally interferes with that expectation of privacy, you got a tort action on your hands. And then false imprisonment, also discussed in more detail in the book, particularly important in the retail environment, and it usually works this way. False imprisonment, by the way, the elements are in the book, but it involves the confinement or restriction of freedom of movement of a victim within a bounded area for a considerable period of time. It doesn't necessarily mean you're throwing them in a cage, but it means that you're making it clear to them. They have to understand that they are being held against their will. For example, if I'm a shopkeeper who thinks that guy just shoplifted from me, and so I have my security officer, good old Bone Crusher Smith, invite him to the back room to talk about it for a little bit, and I conduct a simple investigation asking him if he took something. Would you mind if I looked in your shopping bag there? Do you mind, could you open your coat for me? There's a privilege that the law extends retail merchants called the shopkeeper's privilege. It allows them to conduct basic questioning, investigations, and even detention of individuals as long as they have an articulable reason, meaning they can explain it easily, verbally. Why did you suspect that person? Why did you hold them? And if the person says, I want to go, the shopkeeper can actually detain them for a certain period of time. My security officer, Bone Crusher, says you should wait around another couple of minutes. Shopkeeper's privilege does not magically confer police powers of sworn law enforcement officers on shopkeepers, though. And that's where shopkeepers often get into trouble. They might try to hold somebody at gunpoint. They might try to frisk them, because I saw, you frisk a suspect on TV. That's an invasion of privacy tort, as well as probably a false imprisonment tort. But false imprisonment is another intentional tort, and for retailers in particular, it's important to know what you can and can't do with suspected shoplifters, because if you go over the line, if you cross that line of propriety, and for pity's sake, if you don't call a sworn law enforcement officer to assist as soon as you reasonably can, because the police can do things that you can't as a private citizen. If you don't do all of those things and you detain an individual for an excessive period of time, in most jurisdictions, they're typically talking about 10 to 15 minutes, then the party that you detained can sue you for false imprisonment. And by the way, often when these things come up, it turns out that the person the shopkeeper suspected was not a shoplifter. And they sue and they say, I was humiliated, yada, yada. There have actually been cases, although they're fewer in number, where people who did actually shoplift brought false imprisonment charges against the shopkeeper because of the method or manner used to detain them and the extended period of time. And they were successful in their lawsuit, although they were charged with the crime of larceny, of simple theft, on the other side of that transaction. So now we get to this combination of torts. Again, like assault and battery, they go together. They're kind of wedded at the hip because the elements of the offenses are highly similar. Trespass to chattels and conversion. I think we've talked about chattels before, right? Or do I need to go over it again? How many of you would like a quick definition of chattels? Okay. Chattels, as spelled on the board. Personal property. Anything that you can own that is not real property, meaning not land or not buildings affixed to land. We'll talk about chattels again when we get to property, so it's good to know what they are now. Everything else that you can possess and own and use in your life is a chattel. Your laptop computer, the clothes you're wearing, your shoes, your smartphone, your computer. Personal property is what we would typically call it in a non-legal sense. Personal property, not real property. And both trespass to chattels and conversion are torts against chattels. They're torts against personal property. They're not against real estate. I tried explaining conversion first in the last class, and I think it worked because it's the bigger and more serious of the two claims. So I'm going to try that again with you guys and see if it works as well. And if not, maybe I'll doctor the video so that I address best to chattels first. Conversion is a tort that occurs when somebody who is not the rightful or lawful owner of a piece of personal property, of a chattel, interferes with the true owner's rights of possession and control. That's part of it. Let's start there. Someone who is not the rightful owner of a chattel, a piece of personal property, nevertheless interferes with the rightful owner's rights of possession and control of the property. And I would usually say, here's the but in this case it's an and. There's an extra condition. The interference is so significant that the non-owner of the property who interfered deprived the rightful owner of all of the value of the property permanently. You see that? Non-rightful owner deprives rightful owner of rights of possession and control, and does so in a way that winds up depriving the rightful owner of the full value or use of the property. Now, how do you do that in a conversion claim? There's one of two ways, typically. Way number one is that you actually commit a crime. You steal it. You set your iPhone down at the library to go to the bathroom, and I see it there sitting with your laptop, and nobody's around in that section of the library. And I say, boy, I've been looking for those for ages. Easier to shove them in my backpack and leave the library quickly than to have to buy them somewhere. And I do so. It's an intentional act. I intentionally interfere with your rights as the rightful owner, and I'm not planning on giving them back. And by the way, if the police see me and catch me on the way out of the library, the conversion is still complete. Actually, the criminal theft would be too. Because at the time I made the decision to convert them into what? Into my property. At the time I converted them, I intended my deprivation of your rights in these properties to be permanent. I wasn't planning on giving them back. Yeah?
Could sabotage be included in that?
Well, that's kind of leading to the second form of conversion. If I don't intend to deprive you of the chattel permanently, but somehow in my interference with your property rights, who knows, maybe I was even thinking of giving it back to you. Maybe you loaned it to me for an hour, but I kept it for a couple of days, and then it wound up getting destroyed while it was in my possession, while I had a duty to care for your property and give it back. So the other form of conversion is not necessarily that I intend to deprive you of your personal property permanently, but in some way, shape, or form, when it is returned to your possession and control, it is worthless. It has been, all of the value of it has been sucked out of it. If I sabotage it, if I blow it up or burn it or throw it away, I didn't steal it, I just threw it in the dumpster. Good luck going to find it. Well, you intended to deprive me of the full value of it, knowing that the garbage truck could come by at any time. We're roommates, and I borrow your laptop computer, and I know you won't mind, even though you wind up doing so, because I have a paper to finish. And so I go out onto the high-rise balcony of our upper floor apartment in one of these high-rise buildings that has a lovely atrium, and I'm propping my feet up on the rail, and the kitty comes to sit in my lap, and I push the laptop back down to my feet that are sitting on the rail. Oh, hello, kitty. And then kitty goes, and the laptop falls over the side. It was an accident. I didn't mean to do it. I rushed down to the atrium, and I picked up the little pieces of plastic and silicone and the chips scattered all over the place. that occurred when the laptop fell and hit the ground. Sweep a pile of junk at you and say, here's your laptop back. Even though I didn't intend to intentionally and permanently deprive you of it, when you receive what's left of your property back, it has no value left. That is a conversion. And we call it that because I have converted it to my own personal use, or in the case of the laptop, my own personal misuse. I was grossly reckless with another's property, which I had taken improperly, I had taken wrongfully, and it wound up getting destroyed in the process. That's why the key question for a court in a conversion case, actually also in a trespass to chattels case, is right here in yellow. Plaintiff is suing the defendant for conversion. The court wonders if conversion is the right claim, and so it's going to say to itself, and it's going to instruct the jury to find conversion. Is it fair to hold the defendant responsible for the full fair value of the chattel that the plaintiff obviously didn't get back? If yes, then the defendant is responsible for damages that cover the full value of the item. And by the way, one of the reasons conversion is considered the more serious charge here is that if you make a successful claim for conversion, you may not only be entitled to the full value of the item at the time of its loss, at the time of your deprivation of it, but if, for example, you use it in business and as a result of it being destroyed or stolen, you couldn't use it for that anymore. You can sue for that. Those are damages that you have because the property was wrongfully taken. Other damages can be awarded by a court in an act of conversion. It is considered a serious intentional tort. You don't go around permanently depriving owners of things of their rights in the chattel. So if that's the case with conversion, what the heck is trespass to chattels and how is it related? Famous law professor, probably the best known American tort lawyer, certainly the best known American tort law school professor in American history, was a guy who was doing his thing back in the 1930s and 40s by the name of William Prosser. Prosser described trespass to chattels as the little brother of conversion. And I like that because it's so apt. Trespass to chattels. It's the little brother of conversion. What do you mean by that, Professor Prosser? He wrote an entire article about this. I've got a list of some of his examples too. I may post that in the class forum for fun. But he said, well, trespass to chattels has the same basic elements as conversion. Somebody intentionally and wrongfully deprives a true owner of personal property of their right to possess and control the property. While they are in possession, wrongful possession of the other's property, something happens to the property. It gets injured or damaged or harmed in some way. But ultimately, at the end of the day, in a trespass to chattels case, the rightful owner is usually repatriated with their taken device in some way, shape, or form. Hey, I only meant to borrow your laptop for a couple of hours. I was at the library. Sorry, man, I left you a note on the fridge. Oh, I didn't. Sorry about that. But here's your laptop back. And the laptop is still functional. And you rake me over the coals and say, I'm not sure I want to be your roommate anymore because you go around taking my things without my permission. But yeah, you got your laptop back. I'm sorry, I just needed it. Easier to apologize than ask permission. The laptop is still functional. It has a value. That is not conversion. But then you notice that while it was in my possession, a couple of keys on the keyboard got broken off. Or I borrowed your fancy new iPhone 39 XLZ and I returned it to you with a cracked screen. It's not worth what it was when you wrongfully took it as a result of your wrongful taking of it. It has suffered a diminution in value, we would say. You injured it. That's a trespass to chattels. Because of your wrongful taking, You harmed the full fair market value of the item, but you did not destroy it completely. The thing is still functional. It probably needs repairs. That's why Prosser says trespass to chattels is the little brother of conversion. Trespass to chattels claim doesn't open up that wide scale of damages that conversion does. Typically, the defendant can be put on the hook for repairs to the item. Sometimes if the item comes back in exactly the shape in which it was borrowed, you can still have a trespass to chattels claim because you needed that laptop computer for a Zoom job interview that was scheduled for noon, and now it's 2:30 and you didn't have a computer. And you didn't get the job because you didn't take the interview, and it's because of the wrongful taking roommate's decision that you missed the Zoom interview. If you can prove that you didn't get the job as a result of not having your computer because it was wrongfully taken, even though you got it back pretty much in the shape it was when it was wrongfully taken, you can sue for damages for trespass to chattels. But it won't be a conversion because the chattel itself came back to you more or less without harm. A little more time on the battery, but otherwise, no harm, no foul. Yes? If I borrow my roommate's car, does your roommate know you're borrowing your roommate's car? Okay. I bring it back and there's a small scratch on it. Yes. I was just thinking that'd be an awesome top hat question. If I totaled it, hey, I brought your car back. Great. Hopefully just with a little scratch, trespass to chattels. No, you see the record down there with the pile of rubble on the back? That's your car, right? That's conversion. Yep, that's exactly right. Prosser has this list of things. I think it was a Columbia Law Review article. He's got about 10 or 12 different examples. I'll try to remember to get a copy of that and post it over the next day or so in the class forum so you can see Prosser's examples of what is or isn't a conversion. Yeah. Intellectual property, we're going to talk about that when we get to property, but here's the promo for property. Courts had a real problem trying to figure out if intellectual property could be considered a chattel. Finally, the weight of the law kind of gravitated toward, well, our traditional notion of property is if it's not real property, it must be a chattel. And so when we start talking about intellectual property issues, we're going to find that courts treat ownership rights and intellectual property as chattels. There's a famous case, Cramen versus Sex.com Incorporated, that's in your textbook. Most people look at that case because the name Sex.com is in it. It was a website of, shall we say, slightly questionable material. And the name was basically taken by somebody else who wanted the name of that business for themselves. They stole the domain name, if you will. And the question was, could the rightful, lawful owner of that domain name sue for conversion of the name of the website? Because you have to admit, whether you're, depending on your social mores, that's still a pretty awesome URL to get, right? It's like, wow, it's like getting beer.com. You don't know what you're going to do with it, but you know you're going to hang on to it because it's worth a lot of money. And so that was a major case involving intellectual property as convertible chattel. I think you're going to like our intellectual property segment. Yes, ma'am.
I wanted to ask how the situation would change if there's not a clear owner to the property.
If there's not a clear owner to the property, you have to be the rightful owner of the property in order to make a claim of conversion or trespass to chattels. So can you think of a situation where there's not a clear owner?
Like if you and your roommate get a cat together and you move out and they take the cat.
Oh, that's horrible. I'd hunt them down and beat them. No, never mind. Yeah, and that happens. It has happened sort of to a family member of mine as well. The question in the law would then be who had rightful ownership of the animal, and if the answer is, which it probably would be in that case, if it was a pet that was jointly purchased. We got to get into property law to get to this, but I'll give you a foreshadowing of this. So you two are both waiting for property. You would be considered co-tenants in the cap. And then the question is, can one co-tenant take the animal without the permission of the other co-tenant? And the answer generally is no, not without some kind of agreement or compensation. If you take Mittens, I get the gerbil, something like that, right? You'd have to come up to an agreement. Otherwise, the roommate that converted my cat, your roommate converted half of the cat, but you don't want half of the cat back because that wouldn't be good for the cat. So in that case, you would be entitled to some value if the roommate refused to give the cat back. And you still ought to do something to the roommate. Okay, so that's the difference between conversion and trespass to chattels. Notice that if the court asks the question in a trespass to chattels case, is it fair for a court to hold the perpetrator liable for the full loss of value of this item? And I'm the defendant and I say, Your Honor, I took the iPhone for an hour or two to order some stuff online, and okay, yeah, I scratched the screen, but I'm willing to pay for a new screen, a couple of $100 or something like that, right? I agree, the owner of the iPhone is entitled to a couple of $100 for the cost of the screen replacement. If they go get the screen replaced and give me the invoice, I'll pay them every single penny. But I'm not going to pay them $1,200 on a conversion claim because the phone still works. And with a new screen, it'll be even better than when I borrowed it because it'll have a completely new screen and they're all touchy-feely these days. So those are the kinds of questions that have to be asked. The court would say, Mr. Kuczynski's right in that case. He owes you for the cracked screen. He doesn't owe you for the full value of the item because when you got the item back, it was still a functional item, but for that crack. It was an aesthetic issue. Might have been an operating issue over time, but he owes you for the new screen in any case. Last but not least at the bottom, most people have come across these terms, slander and libel. These fall into a category of torts we refer to as defamatory torts. And if you look at the elements of them, you'll see that they both involve the intentional making of false statements purporting to be fact about someone else. And by someone else, I also mean could be a business. We'll talk about that situation a little bit more in just a moment before we move on. And notice the defamatory torts have these other elements in common. You can't just call somebody a name over the phone and they say, you know that's untrue and you've slandered me, so I'm going to sue you for it. There is what's known as a publication or communication requirement for the defamatory torts. You can't just say it to the target of your slander or libel. It has to be communicated to at least one third party. The publication or communication requirement. And the party against whom the slander or libel is directed has to be able to prove damages in some sort. Reputational damages, lost business, my friends took my things and left town, some kind of compensable injury as a result of the defamation that they're suing for in court. Here is the main difference between slander and libel, and it's important in legal circles. Slander is spoken defamation. Slander is spoken defamation, verbal. Libel is written defamation or in print. It's important what medium the defamation is in. Because if you sue for slander when it's actually libel or vice versa, you can't win any damages because you've misspecified the claim. Yes, ma'am?
What about like a song? Like
Drake and Kendrick. Is that what you're thinking of? There are lyrics, so you could claim libel, but it's sung, so that would be a traditional slander case. I don't actually know who's suing what for whom. The last I heard, boy, talk about two guys who can't get along. I had seen the word slander in a news publication about it. I didn't read the story because, in all honesty, I'm more concerned about price of eggs, World War III, that kind of stuff. But I do know that they don't like each other, and I know that legal action has been threatened. And apparently they're fighting it out in the artistic medium of song, and what better way to solve your dispute with somebody than to do that. So if you tell me that, one of them filed a libel suit against the other, let me see the brief, and I'll tell you that, yeah, this is the correct charge. I can't imagine either one of them filing an incorrect tort charge against the other if it comes to that, simply because they're both very wealthy men and they have access to the best entertainment lawyers that Hollywood has to provide. So I'm guessing that, Stanford top of class entertainment lawyer is probably going to get the defamatory tort or torts correct. And you might also read a complaint and see that the plaintiff is suing for both slander and libel. Furthermore, in states that recognize it, I don't know if California is one. I'm not sure about that. But notice there's also a third form of defamatory tort that's kind of emerged out of slander and libel called injurious falsehood, or the more common name of it is trade libel. It is, regardless of whether it's spoken or written, we still call it trade libel or injurious falsehood. Very similar elements to slander and libel. But if you're claiming injurious falsehood, notice element number 3 here, I have a parenthetical reference underneath it. Because with both slander and libel, they're intentional torts, but the state of mind of the purveyor of the lie has to have a state of mind at least arising to negligence. You shouldn't have said this. You should have been more careful with what you said. Injurious falsehood or trade libel has a higher standard, and it typically is only used when one business interest is charging another business interest with the defamatory tort. One car dealer sues another car dealer for lying about their owner. You could make the case between Drake and Kendrick that they are both very big business interests in the entertainment industry. Drake Incorporated is suing Kendrick Lamar LLC, right? If California recognizes trade libel. But with trade libel, you have to demonstrate that the fault of the purveyor of the lie is engaging either recklessly or with malice against the other party in order for it to stick. So there's a slightly higher burden of proof. I don't typically test on trade libel a lot, but I do want you to know that it exists and it's out there because it is relevant to the business environment. Otherwise, if you're comfortable with slander and libel, we are good to go. Speaking of being good to go, let's talk about 2 other torts that have kind of developed out of the malleability of torts. Remember, I told you, torts are like the Swiss Army knife of compensable injury. Hey, if we don't have a tort for that, but it's kind of related to ones that exist, courts are perfectly willing to hear your argument, plaintiff, for the recognition of a new tort. We'll just figure out what the heck to call it and what the elements of it are, and from what other torts it derives. And that was the case with the first of 2 specific court-created torts that are important to business practice. The first one at the top of the screen is called interference with a contractual relationship. It had kind of been bouncing around the English courts probably for 100 or more years before the case of Lumley versus Guy in 1853. But in Lumley versus Guy, it finally got a name that stuck. An American practice following English practice adopted the tort as well. Interference with a contractual relationship. Before we go over the bullet points, let me actually tell you about Lumley versus Guy briefly, and then you can watch the case review if you need a little more help with it. Lumley was a theater owner. Guy was a theater owner in the West End of London, the big arts and entertainment and show capital of London. And they were competing theater owners, and the competition was pretty bitter. And Lumley landed a whale one day for boosting profits. He managed to sign a Europe-wide famous soprano by the name of Johanna Wagner, spelled Wagner, but pronounced Wagner. Those of you who are into classical music might know Johanna's father, Richard Wagner, Ride of the Valkyries and all of that stuff. North Carolina Symphony's doing a Richard Wagner symphony soon. And Johanna, his daughter, was also musically inclined and a very famous soprano singer. Lumley got her booked to come to the King's Theater, which is what he owned. And he was pre-selling tickets, and he was able to charge pretty considerable amount of money for them. And Guy found out about this contract and said, oh, he's going to get all this business. He's going to be raking in the dough while I'm struggling to bring people in for lesser shows. I may just have to call it quits, because both theaters were kind of struggling. But Guy then developed a clever plan to stop this from happening. He went to Wagner and said, I know you have a contract with Lumley. If you breach that contract with him and agree to sing in my theater instead during your stay in London, I will give you more money. Wagner was not very good at the legal thing. She didn't understand that she was about to breach a contract, which in and of itself is a legal claim. And so she agreed because she wanted the money that Guy was paying. Question: was Guy just a really clever and aggressive businessman, or did he commit some sort of civil offense against Lumley? At the very top level of analysis, it's clear that Lumley had claims in contract against Wagner, right? Because she breached the contract. Lumley took action against Wagner and settled most of those issues. But Lumley wouldn't give Guy the time of day for purposefully sticking his nose in that contractual relationship, because he knew about it. And he did it as a form of, we heard the word earlier, sabotage. Is there anything I can do about that? And that was the case of Lumley versus Guy. Let's look at the elements and I'll tell you how the case comes out. The court in Lumley identified 4 main points or 4 main elements of interference with the contractual relationship. First, there has to be a valid contract between the plaintiff and someone else. Okay, check that box. Lumley had a contract with a third party, with Wagner. Second, the defendant has knowledge of the contract between the plaintiff and the third party. Check that box. Guy knew of the contract. That's why he stuck his nose into Wagner's business and stole her away. Third element, the defendant intentionally and unjustifiably induces the third party to breach the contract. The court said that happened in that case too. Guy knew of the contract and intentionally set out to sabotage it, to sink Lumley's profits and put his theater on even shakier ground. Intentionally and unjustifiably induced Wagner to breach the contract. But for Guy's interference, Wagner would be singing at Lumley's theater and all would be well. Fourth and finally, the breach occurred as a result of the defendant's conduct and the plaintiff suffered damages. Yep, that happened too. Guy caused the breach and Lumley went to sing at his theater and he was happy about that, but then Lumley lost out and he could prove pretty considerable damages. Lumley won the case. The court recognized that Guy's conduct was not just business as usual. It was not good old free and fair competition. It was intentionally trying to get somebody to go back on a legally binding and legally enforceable promise to the detriment of another, solely for the purpose of harming that other party, solely for the purpose of harming the other theater owner. And thus, the tort of interference with contractual relationships is sort of enshrined in American law. What does that mean today? I mean, theater owners and opera singers, et cetera, et cetera. Think about this every time you hear about, for example, an up-and-coming college coach who had a good season getting a new offer from a huge, major SEC or Big 12 or whatever the heck it is these days, school, and throwing a boatload of money at the coach, and the coach says, I still have 3 years left on my contract with Little State University or Little State College. And the big university says, we will pay for the buyout of your contract. I assume just about everybody's heard that term, right? We'll buy out your contract. We will go to Little State College and say, hey, coach has a buyout clause in his contract. Or if he doesn't, what if we compensate you handsomely for plucking your coach and taking him to our big new football school to be our big new coach at the highest levels of the game? And the little college then can say, if there's not a buyout clause in the coach's contract, which would specify an amount, the little college could say, yeah, but you've really got to make it worth our while because we need to find and recruit a coach that is of departing coach's caliber. But if you don't buy out his contract, if you don't settle with us and get a release, you're guilty of interference with the contractual relationship, big football program. You know of the contract he has with us, and yet you're inducing him with a lure of more money to come be the new coach at Notre Dame or Ohio State. So you're going to pay for that privilege, or we're going to sue your pants off to get the money, one way or the other. Your call. A related tort that does not involve contracts is the tort of interference with economic advantage, sometimes called with prospective economic advantage. It's actually a tort that has a number of different names depending on the jurisdiction, but generally speaking, we're talking about economic advantage. And you can see some of the names here. Prospective economic relations. This is a little cutout that I put on the board for you from a published source so you could see the elements easily enough. What is interference with prospective economic advantage? Think about a third party interfering with another party's business, but there's no contract involved in what that third party is interfering with. What that third party is doing, however, is systematically with the intent to harm the target, which will ultimately be the plaintiff in a case like that. They are intentionally and systematically trying to sabotage the target business, the plaintiff, as a business strategy for bettering themselves. Key case from the North Carolina Business Court in 2003, Sunbelt Rentals versus Head and Inquest Equipment. You can't go anywhere in this state and pass a construction zone without seeing something that's labeled Sunbelt Rentals. It's based in Charlotte. It's a massive heavy equipment construction rental company, basically. Backhoes, bulldozers, jackhammers, you name it, they've got it. And Sunbelt, it might not surprise you, has historically had a huge market share in the Carolinas. I used to live in Charleston, and they were big down there too. So they're an East Coast and mostly Carolinas business, and they rake it in. Head and Inquest Equipment did the same thing, except they started in New Orleans. I remember growing up with Head and Inquest all over the place. They specialized in oil well equipment for offshore oil drilling. And Head and Inquest decided they wanted a piece of Sunbelt's pie. They were moving into the Carolinas, and they had a problem on their hands because Sunbelt is literally the 800-pound gorilla in the room. How do you take market share from Sunbelt? We're not going to be able to do it through good old-fashioned competition because they've got the client lists, they have the relationships with the contractors, they've got so much market share. It would not be profitable for us to spend the number of years building a competitive business to compete against Sunbelt. Okay, so what do you propose? Here's what I propose. Let's find key people inside Sunbelt. They're all at-will employees. None of them are contractual employees, so there's no contract involved. Let's go to them and make them an offer. Steal them away from Sunbelt. Tell them to bring their client lists with them, or at least their inner knowledge of their clients and the working relationship, so they can say, hey, Bob, I'm working for Ed and Inquest now. Let's talk rental turkey. And you let them stay at Sunbelt for a little bit after you hire them before you bring them over to sit in an office and I guess play Donkey Kong or something. You got to create a job for them where none exists. But you tell them, hey, part of the gig here is before you come over to Head and Inquest, go talk to your other key staffers around Sunbelt, the ones who know all the clients. Tell them to contact us and we'll make them a pretty darn good offer. Big raise for coming over with all of that information in their head and all of that existing business relationship so that they can talk up Head and Inquist to their current clients and will take them away from Sunbelt. And lo and behold, Head and Inquist's market share started to climb considerably, amazingly fast as a result of this kind of sabotage. If you notice the description in the case, Sunbelt, when they figured out what happened, they sued Head and Inquist under the North Carolina Unfair Trade Practices Act, which is a statutory act, but it includes the common law tort of interference with prospective economic advantage. They said this was not ordinary business. This was a purposeful attempt to sabotage us, to sort of take our place instantaneously by hiring away employees they didn't need, not all of them, just key employees, the ones that had the client lists and the know-how and the experience. They were also made at-will employees, but Head and Inquist didn't really have them do anything other than reveal the information of their client lists and call their contacts and say, hey, I'm at Head and Inquist now. You guys need to start renting from us. It's a great company. I'm really happy here. And so at some point when the defendant goes beyond the pale of what is considered acceptable business practice, a little aggressive competition, a little advertising, big marketing campaign, that's all fine. That's just kind of the rough and tumble world of business competition. But when you try to succeed specifically by sabotaging a company internally the way Head and Inquist did, the plaintiff has the right to damages. So Gordon Gekko's sitting there laughing at this, patting Head and Inquist on the back, thinking, this is a great job of screwing them for business. But notice that the court granted Sunbelt Rentals $16.2 million in damages for Head and Inquist's violation of the Unfair Trade Practices Act and for interference with a prospective economic advantage. The one difference between the two torts that's the most important, no contract required in interference with prospective economic advantage, but the defendant is clearly aware that even in the absence of a contract, the target of their activities is going to benefit from an ongoing relationship with the parties that we're trying to steal away or shy away or whatever from them. Yes, sir?
I was going to ask if the plaintiff would be able to do anything against the 70 senior staff members that went back on them. Like, would they have any fiduciary duty? Was Sunbelt able to sue the people who left? Because they were not contract employees, they didn't breach their contract by going. If you're an at-will employee, not only can you be fired at any time by your employer, but you have the right to quit at any time. So in that case, those employees, I don't know what happened to them because Head and Inquist, I think, left North Carolina shortly after that. I think they did. I have to check on that. So maybe those guys lost their jobs or tried to go back to Sunbelt or move to Alaska. But there was no cause of action against them because they exercised their right as at-will employees to say, I quit, I'm going to these guys. And I'm taking the client list with me, which was the big part of the Unfair Trade Practices Act that the business court had a problem with. So no contract, but definitely conduct that is beyond the pale of normal business conduct.